Hello, can you hear me?
I can hear you. Good afternoon, everyone.
Good afternoon.
Good afternoon. So I know we're starting right now.
Can you hear me?
We can hear everyone.
Yes.
So
I
we're
don't
gonna
know if
start.
they can hear me.
We can hear you. I'm listening to you. So we're starting right now, and this is another series
Yeah, I
in
said,
our web
yeah.
series, and so we are going to. First of all, let me thank everybody for participating in this conversation. If we're going to give you enough time, so you can please share the information on whatever social media platform you have, whether it's Facebook, whether it's LinkedIn, or YouTube. So I'll give you a couple of seconds to do that right now. I'm going to be sharing this information live as well. So if you have a chance, just give you a couple of minutes to start. You share my information to a few pages that I think are important for us to learn more about what we're doing. Share now. Okay, I'll give you a couple of more seconds to share.
The host has okay. Hello. Hi,
Hello,
this is
everyone.
Sherry Hilton Appraisals.
Sherry,
Can you hear me?
of course we can hear you.
Okay, it's hard to hear you. That's why I was just checking.
Got it. I appreciate no problem. Thank you for making sure that we can hear you. I'm just sharing this information on the couple of pages, and let's go ahead and get started. Okay.
Great.
Good. So let me thank everybody for being in this conversation. My name is Al Tariq Kinney. I am currently serving as your Essex County Surrogate here in the wonderful county of Essex. So today's conversation is going to be a conversation about learning more about real estate and the estate planning business. And so we are excited to have experts in this space. They may not be experts in terms of setting up their Zoom or setting up their conference calls, but they're experts in what they do, which is more important than anything else. And so we're going to go ahead and jump right into it. Let me introduce you to my co-host, Mr. Devere McDougall. He is I keep saying this every web series because I want people to know Noor produces great talent. I want to introduce my co-host, Devere McDougall, graduate of Science High School and Rutgers University, CPA, as well as an attorney. He is one of the most knowledgeable individuals in this space, Devere McDougall.
Hello, everyone. I want to thank everybody for joining us, and for those individuals that join us pretty much every week, we definitely appreciate you. Not that we don't appreciate everybody else, but we just want to acknowledge everybody that comes on almost every week. I think Billy Fine is one of those individuals. I think Miss Peggy Giroux is one of those individuals that come on almost every week, and we thank you, and we thank all the new individuals that are also participating today.
Thank you. I want to introduce a young lady who is also a Newark Public School graduate who had the unfortunate of getting accepted and graduating from University High School. She made up graduated from Howard University, and she's a judge, and we're proud to have her participate in this conversation. Miss Melinda Hawkins Taylor.
Thank you. Right now, I practice solely probate, estate. I've been practicing for 20 plus, and I am a proud graduate of University High, Howard, and Rutgers Law. Any questions that we don't get a chance to answer on this, feel free to contact me at 973-441-6700.
Great. Thank you. And we'll also post your website as well. So if people are trying to get in contact, they can go to your website and make sure that they're able to reach you during and after this conversation as well. And also, we'd like to encourage everyone, if you have questions, please type your questions in. We'll make sure we're able to answer those questions while we are having this conversation. I also want to introduce a young lady from Hilton Appraisals. She is joining us for the first time, and her name is Sherry Hilton.
Yes, hello everyone. I was so blessed to have Melinda ask me to join this group and be of service to Essex County and Newark and answer questions in reference to homeowners. And she's dealing with probate, and so many of our seniors in this time have homes and properties that need attention, and they need to be able to go about disposing them and rectifying them in the right way. So I'm happy to be of service and happy to be here.
Thank you for lending us your knowledge and expertise in the space. Let's start off with, I know we have some new guests here, so I'm asking Ms. DeVero, what is a surrogate and what do they do? And maybe tie it into what this conversation is about.
So each county in New Jersey has a surrogate. As you told everybody, you are the surrogate for Essex County. The surrogate happens to be a political office that is in the New Jersey Constitution, and it is a 5-year term. Every 5 years, the surrogate is elected, and so Tariq Kinney happens to be Essex County surrogate, and it's a dual role. It's an interesting position, although it's a political office. It's a judge. It's the only judgeship in New Jersey that has the individuals elected. All other judges are appointed in New Jersey. So the primary responsibility is a dual role. Primary responsibility for the surrogate's court is to be probate wills, administer when there's no will, when somebody passes away, intestate. The individual will need an administrator. So we're responsible to appoint an administrator based on the state statute. So the judge, you're a judge of probate. And so that's the primary responsibility that you handle under that role. You do have some other duties. And the second duty is when we cannot probate a will or perform other acts, we are responsible for being the deputy clerk for the Superior Court. Probate part judges. So that, in a nutshell, that's what it is. But our primary responsibility is probate wills, make sure administrators are appointed, qualify individuals if they need to be qualified as trustees. And we handle approximately $36 million in minors trust funds, which I won't go into too much detail, but that's our primary responsibility. And today what we're trying to do is, because we see a lot of people come in and not understand the importance of estate planning or their responsibility as administrator, we are today, as well as the last 6 to 7, 8 weeks, have been doing this web series to inform people of what their responsibilities are. And so we're very specific today to talk about real estate, because as you see on our flyer, real estate is generally the biggest asset for most individuals, and people a lot of times don't understand their responsibility to handle the asset and who owns it. So that's why we have Judge Melinda Hawkins-Taylor on today to explain the legalities of it, and Ms. Sherry Hilton's on today to talk about appraisal, which is an important part of handling real estate.
So, Judge Taylor, what is a probate attorney? What do they do, and why is this important in this conversation?
Well, in this situation, two things may occur. Someone may pass with a will, and that will must be submitted to the surrogate's office, and any assets, any bank accounts, any homes that are listed in the will in terms of who that person wanted their home to go to, that's what the executor will do. Make sure the home is distributed according to the will. And the probate attorney would oversee all of that. And then you have situations where individuals do not have a will, and that's a lot of situations. In those cases, the attorneys are extremely important, because you have individuals who believe that because they lived in the home, because they took care of grandma and it was grandma's house, that they are entitled to a larger portion than what the law says. And when there's no will, you have to go by what the law says in terms of how that house is to be distributed, and if it's sold, what portion each person will get according to the law.
So Judge Taylor, let's start from how a deed is titled for real estate and explain, because when somebody passes away, there's a deed that is recorded in the clerk's office or the registrar's office, depending on which county that you're in. And the administrator or the executor should get the deed to understand first and foremost who owns the property.
Exactly.
And could you explain how deeds are titled so they can know whether it is an asset that is probate or non-probate asset and what they should look for?
Sure. You should always get a copy of the deed. You're going to need that copy in order to file the paperwork at the surrogate's office. You may need it in filing documents for the state. So before you begin, I always ask, where's the deed? And if someone comes in and they don't have the deed, I order the deed immediately. Why? One, to make sure it's in the deceased name. Because if there's no will, again, you have to distribute according to what the law says. I had someone come in last week. His father passed. And he said, oh, you know, he had a girlfriend, but the house isn't hers, it's my dad's. Do you have the deed? No. I ordered the deed. It was in the girlfriend's name. End of case. There was nothing to apply for the surrogate. The deed overrides everything. Everything. So therefore, you must get a copy of the deed. There are instances where you may have a husband and wife who lived in the property and both their names are on the deed. And it's listed as husband and wife on the deed. If something should happen, I have cases where the children of the deceased will come forward, but they're not, let's say they're the children of the husband, but they're not the children of the wife. They'll come forward, I want my father's share. Well, you don't get anything because it's listed as husband, wife. It automatically, we can transfer the deed into the wife's name. The children will not get anything. And then you have situations where it's solely in the deceased name. If we have a will, it's going to go according to what the will say. If there's no will, we're going to look, that's called intestate. We're going to look to see what those laws say and who it goes to. So then that will get submitted with all of the paperwork to the surrogate's office. Now, who will that go to? Wife. The wife is alive. It may go to the wife and the children of the deceased, who's not the children of the wife. So therefore, the surviving wife and the wife's stepchildren will be sharing an interest in that property, even though the wife is not happy about it. Now, either she's going to, and this is where Sherry Hilton will come in, because I have so many files like this. The wife is either going to, when there's no will, sell the property so everyone can get a share. Or we may have it so that I do have sometimes individuals will say, oh, I know my father wanted her to have it, we'll sign it over. Then we'll sign over the property to the wife. And then there are other instances where the wife wants to buy out the stepchildren. And that's where Ms. Hilton will come in terms of appraisals.
So before we go to the appraisal, I just want to make sure people, because some people will hear these terms and they understand the terms. So the first one you gave example about husband and wife. That's tenancy by the entirety. That means a husband and wife without going into unities and all that. That just simply means,
that's what I was trying to avoid.
So that simply means a husband and wife bought the property at the same time. And both of their names, as you said, are on a deed. Automatically, by operation of law, by the law automatically gives it to the other spouse. And as a result of that, you do not have to come to surrogate court to do anything with that property. As a matter of fact, you do not have to change the deed right away. There may be some requirements where you might want to refinance it, and lender may want to see that, but technically you don't have to change the deed and once it's sold, then that can be handled by the real estate attorney when they handle the deed. You don't have to do anything as a husband and wife if your spouse passes away. So that's tenancy by the entirety. It's not probate. The other example you gave is that'd be if it's only one person. So basically, well, I'm gonna go to it's just they own it so outright. You have tenancy. You also have what's called joint tenancy. So you might have two individuals' names on the will. On the deed. Those two individuals have decided, and some states you might hear them say joint tenancy with the right of survivorship. A lot of times in Jersey, you just hear joint tenancy. Simply means same thing as husband and wife, that it automatically goes to the other person that's on the deed.
Also, if I can just add one thing, that you're correct, it is joint tenancy, but that what they will see is joint tenancy. If it automatically go to the other person, it will say joint tenancy with rights of survivorship.
Right, it can say that. And the other one is tenants in common. Now that's the one where everybody, the example you gave, thinking the stepkids think, they can get 100% of the property. Well, I'm gonna give a different example. A lot of times we get people coming here that it's in the name of the mom and one of the children. And so it's joint tenancy in common. So they're not husband and wife, and they don't want it to pass. So that means they don't want it to pass the other one. So it's not joint tenancy with the right of survivorship. So if mom died first, and let's just keep it simple, they both owned it equally, 50% each. Mom dies first, her 50% will then go to her estate.
Correct.
And if she has a will, as you said earlier, it'll get distributed based on the will. If she has no will, die intestate, then you have to go to the New Jersey intestate statute to figure how it should be distributed. And then so her estate will own 50%, and the child, let's say it was a son, the son will own the other 50%. So now he has to decide what he wants to do. And that's when you come in and you talk about now the property has to be appraised. And let's stretch out that example. And let's say she had 5 other kids. So now instead of him, now her 50% is split out between 5 kids. He still has 50, but he can't do anything without them.
Correct.
He can't sell it or anything. And so what happens a lot of times is they don't all agree. Now you have to look into, as you said, appraising the property. And let's ignore going to court. Just appraising the property, determine if they want to buy out. And so I just wanted to kind of bring in Ms. Hilton and talk about the appraisal piece.
Okay, can I just add in just one thing, just to tackle what you just said? When the administrator is appointed, I do have the administrator being able to sell the property, sign off on all closing documents, and then whatever money is, that 50% of the property, just to follow your example, is then given to the estate and distributed without the signatures of the beneficiary, because the administrator is doing the job in terms of collecting all assets. So the only time I'm finding sometimes when title companies are requesting all beneficiaries to sign is when there's a will, and the will states everyone must agree that it will be sold. But other than that, I have been able to have the administrator sell the property, and whatever proceeds come from the sale, put it in the estate account, and then everyone gets their portion.
Well, yes, that can happen. But I'm with my example, I'm saying, let's say, for instance, that the son that had the other 50%, if he disagrees, then now you got a court case.
Well, if he's the administrator.
Well, let's say he's not the administrator. He's he's somebody else. He doesn't want to sell his 50%. And now it's a problem selling the real estate, because nobody wants to buy real estate where title now. There's problem with the title.
Right.
Because, so that's what I'm saying with that.
Right. And what I tell individuals when they say that, and then usually they'll change their position, is either you're going to sell or you can refinance and buy out the other 50%. And then normally I don't have to, one or the other. They'll give them a little time and they'll realize reality will set in, and they'll do one or the other.
Because if you don't do it, you end up paying extra money for the attorney to fight it.
Exactly.
So let's keep it clean and just say everybody agrees on let's sell the property. And that's not because we know we have examples where we have family members that decide they want to live in the house and not pay rent.
Exactly.
So before we
That's
get
true.
to that, let's just talk about, so everybody's agreed that the property should be sold. Of course, when you come to us at the surrogate's court, we just tell you, just give us the tax assessment record so we can figure out the bond. That's just for our purposes. But for to sell the house, you need an appraisal, correct?
That is
Absolutely.
correct.
And if you can explain to us, Ms. Hilton, the appraisal process, you don't have to go into the various types of appraisals that you wouldn't. I mean, well, I guess if it's a commercial property, but let's just ignore that. Let's just go, this is a residential property. So we don't have to go into the types of appraisal if it's commercial.
Okay. Well, normally, from a 1 to 4 family is considered residential. And my allegiance is not to any family member, it's to market value. And so what I am asked to do is either at the date of death of whoever passed away, all right, and that owned the property or is the owner of record, all right, or sometimes they want the current date of market value. So depending upon what is required and what Melinda might need, then I do an appraisal based upon the date and the market value reflected at that date.
And so I
for
just
that
want
property.
to, right. So, and I just want to let people know the importance of date of death. There's something in tax called the stepped up basis. So if you inherit a property, there is a law that allows that the value of the property now can be stepped up to the date a date of death when it was appraised at that date. Therefore, when it's time to calculate, if you sell the property later on, and if you sell it that year, you won't pay any capital gains because you get the stepped up value at the date of death. Or if you sell it a year, 2 years later, you still may have less capital gains because you got the stepped up basis as opposed to having the cost basis for when the house was bought over the years. So it's important to have the appraisal for tax purposes as well, to save on possible tax capital gains. So that's why you want to appraise it for one of those reasons as well.
Yeah, and also there are inheritance forms. If you are filing inheritance forms, they will ask for you to attach a copy of the appraisal as of the time of death. So if someone has not been appointed, I will call up, let's say Ms. Hilton's appraisal and say, we need a property that's the date on death so that it can be attached to the form. And then other times, and Ms. Hilton, you can tell the difference if there's any. Other times I will say, they want to buy out someone, or there is a realtor, but the beneficiaries believe that the price is too low. We need an appraisal. So I don't necessarily need it for date of death, but I need the market value as of today's date.
Right. So, normally for what you're talking about is a retrospective appraisal. All right. And that is done for back in time. All right. But as your example just noted, if they want an appraisal based upon today's value, Newark is going up, for instance, market value is going up. And so they're saying that at this particular time, we think that the house is at a higher value, then I will do a current market value appraisal.
And I just want to point out to everybody, it's very important as the executor and an administrator, if you are deciding to later on sell the house, even if you're not selling the house, because you need to know the value of the house to make sure when you distribute the asset that you distribute out, especially if you're an administrator, that everybody's supposed to get an equal share, whatever, how much they're getting. Because sometimes, one family member might say, I want the house, and everybody agrees, but you need the value of the house to make sure everybody else got their percentage that they're supposed to have gotten. So you need it for that reason. It's very important to make sure everybody at the end of the day feels as though they were fairly treated. That avoids lawsuits as well. And usually the fights is usually around real estate. And I just want to ask Judge Hawkins Taylor about heir property, because when there's no will, we see that a lot. Where, because I see a question which Surrogate will ask in a minute.
I want to jump in.
Let me just before you ask it. So heir property is simply there is no will, and the property is left to the. So they talk about father or grandfather left the property, didn't have a will, so it goes to his kids. They start dying. Some of them died, then it goes to their kids, great grand. So it becomes even more complicated, and that's why you need an appraisal and determining who owns what percentage. And I'll let you go into that after the question a little bit more about heir property.
So we have two questions that came in from two different people, two individuals. The first question that came in is from Kalina Witcher, who is a regular participant in these conversations. She stated, an elderly father, deed is in his name. His girlfriend lives in and has invested in home improvement. Her name is not on the will. We wouldn't ask her to leave, but want the house after she passes on. She has no children, but nieces and nephews. What type of paperwork should we ask our father to complete in advance?
Well, first of all, if her name is not on the deed, he is the owner. If she is a girlfriend, she has no rights to the property. What to ask your father to complete in advance? Estate planning. You know, if you're talking about a lot of family members and there may be confusion, you know, some individuals may have helped care for the house or him. He may want to give more to one person than another. So in terms of what paperwork, he needs to do estate planning. He needs to do a will. But he can just keep his name on the deed along with estate planning, meaning a will.
And to follow up, the property, and when he passes away, the property would transfer over to his estate, and it will be left up to, and hopefully he will get a will, the executor, if not the administrator, to determine what they want to do with the girlfriend. As the judge said, she has no legal rights to the property. If out of the kindness of your heart, the administrator, executive's heart, they want her to live there, then they can do that. They have to, but remember, their ultimate duties is to the estate, so they should charge her rent. You know, because the reality is your duty as the administrator or executor is to the estate, and when you can ensure that you increase the value of the estate for the benefit of beneficiaries, that is what your responsibility is. You know, not go too deep into it, but people can be sued for breach of fiduciary duty. You are a fiduciary, executor, an administrator are called fiduciaries. You have a duty. You are an agent of the estate, and so you don't want beneficiaries coming in later and say, "Well, you know, you didn't do anything. You didn't do everything properly. So I'm going to go to court and get you. You know, have you doing accounting. You know, which is simply prove to the court you know the money was spent the way it was, you did everything you were supposed to, or try to have you removed. So your ultimate duty is to the estate to make sure the estate you can max out on the value of the estate, pay all the debts. So part of that is if somebody lives there, you have to charge them rent. You have to go after it.
And you know, to add to that, it's not even, I have a case where it's not even someone else, it is someone else living there. You as administrator, executor, you are required to charge rent. It also includes you as administrator, executor, if you're living in that house. You cannot live in the house scot-free because you've been for 10 years and the property is now in the estate. You must pay, and that rent is supposed to go into an estate account to be shared by everyone.
And let me emphasize, that means if you're the brother, you're the sister, that includes you too, because we see a lot of fights because brother and sister think they should stay there without paying rent.
That's right.
You can't do that.
That's very true.
If they were paying rent before?
It doesn't matter.
It doesn't matter. All right.
Now the property is not in mom's hand, but in mom's estate. And that administrator, executor, as the deputy stated, they have a duty.
We have another question that came in. Please explain, if a husband and wife are on a deed, one spouse dies and the other spouse becomes the sole owner. If the only living spouse dies a year later without a will, what should the heirs do? Who would the property belong to? Which New Jersey statute governs this topic?
Well, let me see. I'm reading this thing myself as you stated.
Title 3B is a New Jersey statute that you have to look towards when it tells you first of all it's gonna dictate who's entitled to be the administrator. It'll tell you that, but also it'll tell you how the property should be distributed. And it's very important that if you don't quite grasp everything in what the statute says, because sometimes some statutes can be convoluted, you should seek legal help. And I will admit I am biased, but the more complicated it becomes, the more likely you may need an attorney who specializes in that area.
And I don't think you're being biased, because here's the truth. You can go and read a statute, but you and I know, Deputy, that there's a lot of case law, which would help you understand that statute. There are other forms that the individual may not know. So depending on the complexity, whomever, you may want to seek out, your family attorney or whatever to assist you, because this having property in an estate puts it in an entirely different playing field.
That's true.
There's let me see. There was another question that came in. I have 4 children, 1 adult child and 3 underage. I adopted. When I pass away, not pass away. How can these younger children get their shares?
Estate planning again. I mean, if there is, it doesn't say whether or not this person is married. So I'm assuming they're not married, and it's just the 4 children. If she's adopted them legally, the best thing to do is to provide for them in a will. And if they're under a certain age, sometimes I even have, individuals do a trust, so that one individual, an adult, can determine how these other children will receive the money. And then I'll let the deputy, touch upon the minor account that they have in the surrogate's office.
So let me start off by first saying adopted children, half brothers, half sisters, are all the same. They're equally entitled to an estate if there is no will. So let's take the example and assume that from how I'm reading it, you don't have a will right now. But I do agree with the judge that you do need a will. But let's say you don't you pass away before you do a will. They're all entitled to the equal amount of shares, whether they are adopted children. Because as you know, when you adopted, the judge told you that they're considered to be your children as if you had given birth to them. So they have equal rights to inherit, just like your one adult child that wasn't adopted. And even if you had kids that would be considered half brothers and sisters, no such thing as half brothers and sisters in the world of estate law. So I just wanted to point that out. And in terms of minors, what happens if you don't have a trust set up for the minors and it's an administration, we send you to Superior Court. You have to do an orders for cause to verify complaint, because we don't really have to say here at the Surrogate's Court about real estate. We can't hold real estate as opposed to cash. If it was cash, we can hold it and put it in our minor's trust account. Real estate, unfortunately, we can't do that. And so what we do is have people go to the Superior Court and ask the judge what to do. And the judge usually probably will put it in a trust. If he thinks it's better for the minor to have the house sold and then have those funds put into our trust account, our intermingled trust account, then that will happen. So anytime a minor is involved, the Surrogate Court this Essex County Surrogate Court has the administrator go to Superior Court to have a judge determine how to handle those minor children interests. So, because just like what I'm reading in between the lines, because we want to make sure, and the Superior Court judge wants to make sure, is that those children aren't cheated out of their inheritance.
And that just goes to just underscore even more important. If you have property, you have children, you have next of kin that you don't get along with or you haven't seen in 20 years, you need to do a will or a trust, because they may wind up getting everything.
Sherry, I have a question. Sherry, I have a question for you, because I know
Yes.
at some point, someone will, or the estate will come to you and say, well, the value that you are providing us is not reflective of what we think the property value might be. Or, they may say, well, I think I'm entitled to more because this property has increased in its value, we believe. Or you may say, well, a family might want to give less, and they challenge the appraisal values. Like, what role does this play in this whole estate process? And some of the difficulties you witnessed, in these processes that happen over the years that you've been working in this space.
Well, as Melinda stated, estate planning is so important because most squabbles and fights among family is because people don't plan to fail, they fail to plan. And so what happens is that a challenge will come about because either one person is greedy, one person is this, that, or the other thing. And so if a challenge happens, and that's why on an appraisal, I have to document why I am giving a particular property a value. We don't pull it out the sky. I have to support it with the market, with sales, and I have to also support it with what is the current condition of the property at the time of inspection. And so when I inspect a property, all right, I am not just looking for, something ethereal. I'm looking for, all right, is this kitchen been updated recently? What's the basement looking like? Has it been painted? All the things that add value to any other property. And that's what makes it worth what it's worth, and also what has sold in the area in that particular market that would dictate where this house would fall. So go ahead.
Is that called the sales approach, correct?
That's called the sales approach. The cost approach is not really relative in, I'm going to say 98% of properties, 1 to 4 family properties, because the cost approach is basically dealing with new construction. All right. And that's usually not the issue. So the sales comparison approach is what is normally relied upon.
And so when you check the market, you're looking for similar type of houses, square footage.
Footage, room count, right. Amenities, yes. And like the lot sizes.
Right. And like you said, you look for if there was improvements to the kitchen or the bathroom, you factor that in, or if there wasn't, you factor that in, you make adjustments. Because
exactly.
You have a in-depth report that you provide to whatever attorney. In this case, we'll just use Ms. Taylor. Judge Taylor. So if she hired you, you would give her an in-depth report that would break it all down in terms of how you came up with the value, correct?
Mm-hmm.
I have a question. I'm sorry, go ahead, Sherry, go ahead.
Go ahead.
No, I have a question because are you looking at, when you do your market analysis, are you looking at the property as it values today, because or projected value? Because and this might be me. If I deviate, please correct me, get me back on track. We have a train stop that's being built in our neighborhood. And so I just want to know if I can increase the value when I put it back onto the market, or when it's appraised, or are they looking at today's value in terms of how you do your appraisal? Because I want to sell it for $700,000, but
yeah, I'll say, yeah, you're going a little bit offline. That's a different type of appraisal.
I had to ask the question. People want to know the same question.
Well, all things being equal, all right, and say the property's in great shape, I am going to mention in my report that based upon changing neighborhood factors, all right, this is going to benefit the property because of what's happening in the neighborhood. So we do give some kind of adjustment based upon that. But now it's not going to be the same as maybe 3 years from now when prices have actually gone up. All right. And then it's not a projection. It's a concrete fact that this has actually happened in the marketplace.
And I
And
apologize.
that's different. No, that's okay. And that's different from, let's say, your property, you're going to renovate it. All right. Or you're going to buy a house that's in an as-is condition and you're going to renovate it. All right. So I may give you two values. I may give you your as-is, and then based upon the scope of work and what you're going to do with the property, I'll give you an ARV, or as complete, after repair value, or as complete. All right. And so that would reflect the higher value as well. So to answer your question, all these factors do enter into a value, okay? But market value is pretty much as it stands today, or what the improvements will be as of tomorrow.
Got it.
And let me just add this. Let me add this. So with an appraisal, it all depends on the purpose that you need the appraisal for. It's
Absolutely.
Like it's evaluation. So if I want to do property tax appeal, I don't know if Ms. Hilton does property appraisal for property tax appeals, but if I wanted to do property tax appeals, the appraiser is going to appraise it based on what I need it for. And there's certain requirements with property tax appeals in terms of there's a floor and a ceiling limit, which I won't go into. So she's gonna skew her appraisal based on my purpose. So it's always about valuation.
And there's a time frame for tax appeals as well.
Right.
That I can only, right.
So if I were to hire do a property tax appeal for my apartment, she knows the general deadline is April 1st. There's some exceptions here. The general deadline is April 1st. But that's going to be totally different if I wanted her to do the property tax appeal because I'm an appraisal because I want to sell the house. I want it to be as high as possible, and she's going to have that in mind because she knows my purpose. So once she knows the intent of why you want the appraisal done, she'll skew it towards that. But like she said, she's the expert. But like she said, market value is market value. But she will consider what your purpose for the appraisal is.
One thing I would like to add, Surrogate, I think you touched upon a great point in terms of the train station, because I have a client, this is going to tie in the appraisal too. I have a client who lives in walking distance of Wassesing train station. And a lot of administrators, executors, you will find once you file to become administrator, executive, surrogate's office, a lot of investors will then obtain your name, your number. I don't know how they get your number, but they get your number. And they start calling. Oh, I can buy your property for this amount, cash value. We'll close in 2 weeks, even though that never happens. And my client, an elderly person, had received it and was about to sign the contract. Her house needs work, but was about to sign the contract for $135,000. But I kept saying, wait a minute, you're close to the train station. How could this house be $135,000? Got the appraisals done. She immediately listed. The house sold in 5 days for $240,000.
So I can kind of sort of answer the question is how they get the names.
Well, that's what. Oh, okay.
I kind of know the answer. So I answer that question. So when it comes to an estate, and if somebody got appointed administrator on an estate, then those records are public. And so anybody can come to the surrogate's court and check the records. And we have people come here all the time speculating. I will leave my personal opinion out of it. But I will say this to any individual that does go to any surrogate court to find the name of administrator executor, keep in mind that in all likelihood, that administrator executor is a family member. That was their loved one that passed away. So be respectful. Don't call them almost the next day. I mean,
they do. You're talking about investors.
Right.
They do.
Right. It's 10 to 5. Well, you can't. There's limits on when a will can be probated and when administrator is appointed. But in essence, the person's still grieving. So keep that in mind. Don't try to call the person right away when the family member just died. That's just respect, common courtesy, human decency. So keep that in mind. And if they say no, don't continue to harass them. I just wanted to. Now I got a little personal with that one, but but yeah, the information is public information. It's nothing that the surrogates court can do about it because that is the law. The information is public. The name of the executor, name of the administrator. We redact important information like no social security numbers for the decedent and anything like that. But administrator and executor's names are public information.
Mm-hmm. And Ms. Hilton,
Piggybacking
in terms of investors, have you run into like when an investor has given someone a certain amount and have your appraisals come in totally different? Because investors, I found a lot of times try to lowball.
Yes. No matter who you are, and especially amongst people in Newark and Urban and Essex County, it's important that, and elderly couples, the house may need work. And you've had the house for a long time, but you still need to have that appraisal to know what the house is actually worth. And I have a saying, you know, a good deal isn't a good deal unless it's a good deal for everybody. And the only way for a homeowner to know, okay, yes, my house needs work, but this is what it's worth. I can negotiate, but so much, but give me a good baseline to start my negotiation. If I want to get rid of the house, whatever I want to do with it, give me a solid baseline. And that's what the appraisal does, because you're going to negotiate with whatever investor. But at that point, you'll know if the investor is giving you a song and dance, if they're trying to rob you, what is fair.
Right.
And that's what you need to walk into this with, an understanding of what market value is and what is fair. And then you can decide from there. But someone just rattling you off a number, okay, and they're thinking that you're in some kind of situation and they're taking advantage, you'll never know that unless you know what the house is actually worth by somebody who is unbiased and does not have, you know, a quarter, you know, in this dollar.
So, you know, I wanted to add just a commentary, because I think Sherry hit on a few points, as well as Judge Taylor and of course DeVero, about, you know, someone mentioned in the thread, don't sell mama's house, right? You know, unfortunately, mama passed and we inherit the house, and because we don't want the responsibility of taking care of the house or maybe the commercial property, we sell for whatever first offer that we get. And I think based on what Sherry's saying is that before you do that, before you make that decision, get an appraiser to find out if you are getting a fair market value when that decision is made. Because we witnessed a number of times in this, you know, in this space, and you know, we've seen people who decided, well, I don't want to either live in this particular neighborhood, I don't want to live in this particular area, or this house has too many memories, you know, of my loved one. I just want to remove the property and get rid of it. But an emotional decision could take a lot of wealth out of your own household, you know, out of your own family. And then that's what Sherry is saying, is that get an appraiser, find out what the price is, and make sure it's fair on behalf of all members of your family, because it can impact generations.
Well, as I said earlier, it still is your duty as the fiduciary. It is your legal obligation to ensure that you're getting the maximum amount out of all the assets. So appraiser will do that for you. So I mean, you have to do it. It's your responsibility. But I just want to go back and have to use my experience as doing real estate. When you're talking about investors, many of the individuals that have approached my clients weren't actually the people that were buying the property. They were what we call straw men. They were individuals put up to act like they were investors, because it was also a way for them to circumvent being a realtor.
That's right.
And so
very true.
So I've always had my client, as you said, get an appraisal, but also tried to make sure that they understood that individual is trying to lowball you because they know that they have a true buyer down the road. So why are you dealing with this middleman? So appraiser will avoid all that, even if you don't know that they're the straw man, the middleman, and trying to, as Sherry said, basically trying to take advantage of your situation, whether it's because you're emotional because mom or dad died, or you're elderly, or you simply don't really understand the market. they're trying to take advantage of, or they just simply think, and I'll be honest, they simply think you're stupid.
Mhm.
Well, you know, if,
yeah.
and if I may say, there's different functions in the market, okay? And so you're going to have people that are looking out for investors to find them properties. You're going to have actual realtors, all of this. But at the end of the day, if the homeowner knows what their property is worth, no matter who comes to them, they are dealing from a position of strength. And so it's really hard to take advantage of someone when you know what you are holding. And on another note, you know, our homes are normally the largest purchase we will ever make in our lifetime.
Mm.
A family member or whoever left you the home, mom, dad, grandma, they really blood, sweat, and tears to have a house to be able to leave as a legacy. So it is incumbent upon you to do right by what they fought so hard to attain.
Mm-hmm.
You know, and really work with that property. So because they did it for themselves and they did it for the generations to follow. So it's incumbent, like you said, to actually do the due diligence that needs to be done, so you know what the property is worth, you know what you are handing down, you know what you are giving the family and the generations to come. That some of that money might put somebody through college, you don't know. So it's really important to have a firm baseline of value on the property.
Right.
So I know we have a number of people participating in this conversation, and I have a young gentleman who is online he's a realtor, and about creating a lease in these situations. If you can provide some detail in terms of, well, first of all, put his information up online, as well as, the process of creating a lease in these sort of circumstances. That'd be great for people to get more information about on a number of levels. One is, he mentioned about, if you have somebody living in your house, who happens to be a family member, and you're obligated to make sure that the estate is receiving revenue, you can create a lease or charge rent at the cost of the taxes and mortgage. That was a recommendation that he provided, to someone living in the house, because of the fiduciary responsibility you have. And so we also have someone that
May I comment on that one for a second? For the lease, if you're going to enter into a lease and you're the administrator executor, make sure it's month to month. Because if you make an annual lease and then you attempt to sell the property, the new owner may have to take it subject to the tenants who are in there, and you're not doing yourself justice. So you want to make sure, yes, it's in writing, but it's month to month, and that lease allows the tenant to know that you may sell, and they may have to move, even if it's 4 months. So I would just add clauses. Because when you're an executor, administrator, don't try to go to Staples and get the standard form. It will not work. Won't work.
Thank you.
Mm-hmm.
I know we're about 7 minutes away. If anyone else have any questions, please make sure you post those questions on the thread below. Someone had a question about property managers. Can you elaborate on that? And I'm not sure what is it tied into. Aisha has a question about, someone recently told me about having a property manager. I'm assuming it's regarding real estate.
I understand it. So a lot of times when people own real estate, they want to invest in real estate, but they don't want the day-to-day responsibility. So they hire a property manager, and the property manager will be responsible for collecting rent, for making sure that repairs are done. And I'm a little outdated, so correct me if I'm wrong. Generally, they get 10% of the rent. My number could be wrong, so don't quote me on it, but they get a percentage, usually get a percentage of the rent. So that's what a property manager does. That's their responsibility, to manage the property for the owners who want to invest but don't want the day-to-day responsibility of taking care of the property. And a lot of times real estate companies offer that services as well. And there's property managers outside of the real estate industry, but real estate agents, their companies sometimes offer that service.
Mm-hmm.
That is true.
Great. So I have a last question, and this may relates to everything that's been happening in the last 3 months. COVID-19 has changed the world, as we know, in terms of how people are either getting appraisals. I'm not sure if you can elaborate on that. The
Yes.
number of properties that have came back onto the market because unfortunately people are dying. Can you tell me a little bit about what regulations, maybe habits that have changed in the last 3 to 4 months that's impacted your space, whether it's probate or whether it's an appraisal appraisal space as well?
I would say for the most part, it has to do with our inspections. On a regular bank loan, a Fannie or a Freddie, in some instances, we're not required to go inside the property. And so we can do an exterior only and speak to whoever is in the house to get an idea of what is happening inside the house and ask for some interior pictures from the homeowner or whoever is occupying the residence. In terms of sales and in terms of pretty much because interest rates have gone down, there's a lot of activity in the market right now. A lot of refis are happening because interest rates have gone down. So for the most part, it's not like when the market crashed in '08 and all these banks went out of business. Quite the opposite. Interest rates have spurred the market on somewhat. So we've been busy.
Mm-hmm. Mm-hmm.
Jess Taylor?
I would say in terms of how it's impacted, a couple of things. One, clients are having to wait longer in order to get the death certificate, and therefore there's a delay in applying. I guess it's, everything is just backlogged now, so it's taking a lot longer.
Yes.
Individuals, I'm finding, when I ask for certain paperwork that's required, the paperwork may still be in that apartment where the person actually died, or they may be in the home and the home has not been sanitized yet, or they don't want to go in. And, so then I will work with them in terms of getting in some type of cleaning company to come in so they can get to the paperwork. And then lastly, probably one of the most important things, it would be, I see individuals coming in and they're not next to kin. We have a girl who lived with this guy and she knows that there's an uncle somewhere out there, but she's not sure. She was actually allowed to bury him. She did everything. There's no one else. And now we have to run searches. So, because of this COVID, you're seeing a whole lot of, situations, not family members, but people who are basically like family applying, and you have to take extra steps.
And I just want to add to that piece. So when the person is not a family member and they want to, let's say, bury them, it is possible. You have to do an order of cause, verify complaint, and submit it to us here at the Surrogate Court, and we'll work with Superior Court to get a hearing date for you. Understand my experience has been the judge will allow non-family members to bury a friend or a co-worker, if generally knowing with the understanding that they will probably not be reimbursed for that. But the judge normally doesn't put them in charge of the general, make them a general administrator to handle the estate, the real estate. If there's nobody there, the judge will find an attorney from a list of attorneys that they have. So I just want to make that part clear to people. If you're going to do it out of the goodness of your heart to bury a friend, a co-worker, you're going to be responsible for paying for, in all likelihood, if they didn't have anything, and you may not get that money back. But you're not going to necessarily be in charge of their assets, their house, which most people think that they can get the house, sell the house, and get their money back. The judge is not going to necessarily do that. So you can try, but I just want to make it known to you that in all likelihood, you're not going to be in charge of the real estate and all the other assets.
What if it's
So it happens. It's possible, but it's less likely if you're not a family member.
Well, what is the surrogate's position if it's a girlfriend and the girlfriend and the person who died had children together and the girlfriend, because that's what I'm girlfriend wants.
Right. So that's a different. That's an exception to the rule. That's an exception to the rule because the children legally have the ability to handle the estate, and they're going to legally be entitled to inherit. Because now, if the children are minors, is what I'm assuming you're saying. If the children are minors, then the girlfriend, their mother, has the authority to decide on their behalf who can handle the estate.
Correct.
So, but if there is real estate involved, again, we can't hold real estate. We don't make a decision on real estate. You're still going to have to go to Superior Court for that. We can put you in charge of handling the estate in general, but you still need court approval, Superior Court judge, probate part judge, approval on how to handle the real estate, whether that should go into a trust or sold, and then, as I indicated earlier, the money put into the intermingled trust account. So that's one of the exceptions to the rule, because it technically is a family member. It's the children. It's just the children have the authority to make decisions, so their mother, their legal guardian, will be able to do it. And if you have questions, just call us here at the Surrogate Court, and we'll explain that more.
Comments, Ms. Cherie?
Question. And I haven't heard this term in this conversation. Common law without children. How does that fall?
No such thing as common law in New Jersey.
So you
don't have legal rights. You're just a girlfriend or boyfriend in New Jersey.
Even if it's 25 years, you've been living the 25 years, it does not matter.
Yeah.
So, all right. I think people need to know that, because you hear those terms and we haven't discussed that. So,
you're right.
For those who live with their long-term mate, it would be in your best interest to get married. Is that?
That's right.
I agree.
Before we wrap up, because we actually have a 1:00 budget meeting, we're 2 minutes late. Before we wrap up, I want to get at least one recommendation, because I know, we've had this conversation, and it pretty much highlights some of the reasons why we decided to do this series, is because we wanted to talk about some of the real issues that impact families, how we can preserve our if we have transformational wealth, how do we preserve it, how do we plan for family members, how do we prevent ourselves from being taken advantage of, how do we use what we have to make sure the next generation can build off of what we have without losing what we gain. And to what Sherry said about, your blood, sweat, and tears, all the work that I know my mom put into owning her own house, when she made it a point that she was going to buy a house and raise 2 boys, in the city of Newark, and made a commitment that she was going to make sure that house was going to stay in that family for years going forward, and she did that, and it's our obligation with my children to make sure if something happens to her, that house stays within the family to the best of my ability. So I would love for you to offer some recommendations, some guidance, before we leave, for the rest of the evening. So whoever goes first, any recommendation?
Well, what I would recommend, and this is why I was excited about this particular subject, because it is so well needed. I have clients come in and they want to sell before getting the appraisal. And while they're talking to me, I'm kind of upset. I'm on the computer and I'm looking at what I can find on the computer in terms of, informal appraisers. And, it's upsetting because individuals are being taken advantage of in terms of getting the value they don't know. They're transferring deeds before it's time in terms of administration. They're doing it backwards. And then when I come in, I have to reverse what they've done and then start from scratch. So, my recommendation is, one, I like, Deputy McDougall stated, My recommendation is if there's property in an estate, you need to have guidance to make sure that as administrative executor, you're crossing your T's and dotting your I's.
And I will add, I just want to mention something about a deed. So some people listen to a lot of these programs about estate planning and stuff like that, and they're very good. But always remember, this is New Jersey. New Jersey laws may not apply other state laws do not apply to Jersey. Give one example. People may have heard of something called a ladybird deed. We don't do that in New Jersey. That's a way of taking a deed and transferring a property. It doesn't work in New Jersey. So if you hear something, always do your research. If you're doing it on your own, do your research to see if it applies to New Jersey. But I think even as important, more important than that, just as Judge Taylor indicated earlier a couple of times, I'm going to emphasize it. Estate planning, do a will. If you want to make sure it stays in the family, you want to avoid fighting. The best way to do it is estate planning. And I know sometimes our family members, probably at this time, some of them may not have the mental capacity to do it. Then you need to bone up on the estate laws, how to be an administrator, and that is Title 3B. You have to go into it to see the nuts and bolts, but also seek legal assistance if you need it. It's nothing wrong with admitting that you need help, because we all need help at something. So also don't be afraid. Seek legal guidance if you don't think you can afford it. There are some legal services out there that may be able to help you out if you can't afford an attorney, but there are some attorneys that charge respectable prices.
Mm-hmm. And if I may just add just one more line, just a disclaimer here. Yes, I'm a judge, but I'm not appearing on this event as part of the judiciary. This is just part of my practice. I know some of you know me as judge, and I've heard that, but just for a disclaimer.
We appreciate that, Sherry.
Well, I concur with what's been said. An ounce of prevention is worth a pound of cure. And you have elderly family members, go to them, start having the conversation. Many of us in our community, we don't want to talk about the inevitable. It's like we're speaking it on them. No, we're not. What we're doing is making sure that they have peace of mind, and going forward, there's peace of mind in the family. It's keeping things cohesive. So do what's needed to be done. If you find that you are the person, step up. Right. Go to your grandparents, go to your parents and say, let's have this discussion. Let's talk about it. All right. And give them their flowers while they're living. And part of that is helping them do what's necessary so they have peace of mind. That's love.
Thank you very much. I appreciate it. Now, I know our role in this office, we can't make, referrals or recommendations about who people should use in terms of whether they need legal services or appraisals, because we can't refer people that way. But, you should always, identify people who are able to who decide to volunteer their time and use those individuals, because, they made it upon themselves to ensure that you were able to get information, to ask them questions. And my recommendation is that, is to echo everything they said. You need to, look at getting an attorney if you need to, in terms of getting estate planning, as well as if you decided to make any sales, you need to get an appraisal. Again, it's, I can't give, any recommendations, but but use the information that you see in front of you if you need to. With that being said, I want to thank you very, very much. On behalf of our court, your knowledge in this space is very, very appreciated, and you volunteered to offer us as much information, and we learned a lot. I know I learned a lot. And it gave me some direction as to what I need to do in my own family, and have those tough conversations with family members in my life as well as, up the sale of my property that's next to the train station.
I am honored to participate.
Very much.
Thank you.
Right. Thank you, everybody, and have a wonderful day.
All right.
All right. God bless.
God bless.
All right.
Bye-bye.
Bye-bye.